Welcome to the webinar brought to you by OSHA Technologies. OSHA Technologies is a global leader in oral fluid substance abuse testing products. The assays provide accurate and easy-to-administer testing methods to help determine the presence or absence of drugs or alcohol in a person's system. Fluid-based testing products provide a simplified collection process, faster results, cost savings, with minimal risk of tampering, and dramatically reduced risk of adulteration. Intercept Oral Fluid Drug Test is an FDA-cleared laboratory-based oral fluid drug testing system that enables accurate testing for drugs of abuse, including marijuana, cocaine, PCP, amphetamines, methamphetamines, barbiturates, benzodiazepines, methadone, and opiates. Ranked as the #1 recognized brand name in oral fluid testing in 2016 National Drug Testing Industry Survey. With an easy-to-administer collection process, Intercept is ideal for workplace, criminal justice, drug treatment centers, and clinical setting screening programs, among others. Today's presentation is entitled After the Vote, Marijuana and OSHA Updates and the Impact on Workplace Drug Testing. Today's presentation will be presented by Nina French and Andrew Current. Nina French is the managing partner of the Current Consulting Group with over 24 years of experience in employee screening. Nina is Vice President of Employee Health Programs, later First Advantage. She specializes in product and business development, occupational health and wellness operations, and drug testing, marketing, and sales. She's an expert in all facets of drug testing and employee screening operations, including staff and compliance monitoring. Her consulting emphasis is on helping employee screening providers streamline operations, launch products, increase revenue, and retain existing clients. Andrew Current is the Compliance Director for the Current Consulting Group. His responsibilities include researching state and federal laws, managing the company's online state law database website, and serving as the managing editor of the e-newsletter State Drug Testing Laws Monthly, as well as BCG's other publications. It will be a pleasure to hear from Nina French and Andrew Current.
Good morning, everybody, and thank you again for joining today's webinar. We're going to launch right away because we have a ton of content, and the content today is really broken down into 3 parts. We're going to cover the update on legalization of marijuana, last week's elections, and explain to everyone, what happened, and an overview of each of those laws and the impact of them. And then we're going to move into the overview of the OSHA record-keeping rulemaking. And, it's interesting today, we have a ton of attendees on the phone from sort of all over. OSHA is causing a lot of confusion for people, and we're seeing that as we're creating content and doing trainings on OSHA, people are really gobbling it up because there does still, there's still lingering confusion, and there's still updates to that. So we're going to cover that. And we're going to talk about the role of laboratory-based oral fluid drug testing as it applies to both of these things, and cover some of the general information, but really try and help you walk away from today with an understanding of sort of reframing the impact of marijuana, and then ways that you can use based oral fluid for today's testing environment with OSHA and with legalized marijuana. So run through them relatively quickly. But we started the presentation with some of these numbers. And what's really important as we talk about legalized marijuana is with the team at OSHA, and we've talked about this, and lots of us have been in this industry for a long time. It's almost sort of missed the point as marijuana was coming legal in the country. And today, what we're finding is that numbers are coming in, and the numbers are helping us to come to a conclusion that's very different than what we've been talking about in the past several years in sort of legalization, and is it going to happen or isn't it, and are we pro or con? We hope to walk you away from today with really a reframed thought on that. And so we're going to start by showing you some of the numbers that are coming in now since marijuana has been legal. So the first is 13.5 million and then 22 million. So in 2014, 6.6% of adults aged 26 or older, comes out to 13.5 million adults, are current users of marijuana. So, 6.6% might not seem like a lot, but 13.5 million sure does to me. And current users are users who've used it in the past 30 days. We're not going to cover each one of these, by the way, but the information's here, and you'll get copies of these slides so you can see it. This was confirmed in the 2016 Gallup poll. So we're seeing that it shows 13% of Americans report being current marijuana users compared to just 7% in 2016. I think when sometimes you see those single-digit numbers, you think, oh, well, it's 7%, 13%. That is gigantic. That's a doubling almost of the number of people reporting to be current drug users in just a 3-year period. When you apply that to the total population of the United States, it is a staggering number. If you are an employer, someone is working for you. If you look at the 22 million illicit drug users 18 or older, 7% are employed full or part-time. So think about it, right? 18 years, it seems like you're very young to me, but those are people who are in the workforce. Those are the people who are doing the summer jobs. Those are the people who are the seasonal hires. Those are the people who are your lifeguards at the pool when your kids are there over the summer. Those are, So you want to think about it. Those people are in your workplace. The next number is 52%. And again, think about these not as the number, but think about these as how they compare and what the trend is. 52% of Americans now say that marijuana should be legal, and 42% think it should be illegal. The jump is from 60% who supported it in 1990. That is a huge jump. Statistically, we don't see numbers like that in general social surveys across the United States. It is a fantastic swell of support for medical marijuana. And then 16, 20, and 2 and 13%, that number is from a CAP study. And it's here to show you as employers and looking at the impact of marijuana, what the cost of turnover is. You go to the Department of Labor and you can find much more specific turnover numbers that are by industry, by job type. But in general, the CAP study shows that 16% of an annual salary is for a low-paying job, $30,000 a year or under. And those are a lot of the people who are dealing with the cash because they are in a service industry. They're working the cash register, right? There are things like that. They're doing perhaps manual labor. Accidents can happen more often than sitting at a desk. I mean, I could tip her in my chair, but it's not going to really hurt anybody. 20% of annual salary for mid-range positions, so $30,000 to $50,000 a year. So losing one person in that position is going to cost you about $8,000 to replace them. And then when you start to get into annual salaries for higher educated executive positions, highly technical positions, it can swell to as high as 213% of an annual salary. And so why is this important? Well, you saw those numbers about the percentage of drug use. You saw how rapidly they're increasing. And drug users are proven statistically to turn over their job on average 3 times a year compared to an average employee, a non-drug using employee. So as an employer, those numbers are real. You may track your own turnover statistics. Those numbers are real because they're impacting you as the drug users continue to turn over in the workplace. I'm going to turn over now the slides for Andrew, and he's going to talk to us for a few minutes about the legalized recreational and marijuana, and then we're going to pick back up and start to tie in these numbers to the impact of what this new legislation means. So, Andrew, I think the ball and
Thank you. So if we had done this presentation a month ago, this would have been a lot less decorated. We have Alaska, which was already there, but a new one is California. DC and Colorado were there, but new additions are Maine, Massachusetts, and Nevada, and then Oregon and Washington, which have been there for a while. We saw four new California, Maine, Massachusetts, Nevada all vote yes. And we're going to look exactly at some of the details from those new laws and how they impact workplace drug testing, workplace drug-free workplace policies, discrimination, discipline, and all of those types of questions. But I mean, the number of states doubled, and I don't have the exact statistic in front of me, but it's about 25% of Americans now, adults, access to recreational marijuana, where it had been, some small percentage 2 weeks ago. Now it is just 25%. Look at some of the states passed medical marijuana, but that also increased. New states added medical marijuana, and so that's somewhere around 54% of Americans have access to medical marijuana. So a huge shift in access and legalization. And if we look at these states have in common before they legalized recreational marijuana, and that is they all had medical marijuana. And it's held true over the last few years that if a state has medical marijuana, they're likely to have recreational marijuana. And so far, no state has jumped straight from marijuana to recreational marijuana. So this list now have 28 states, including Washington, D.C., that have medical marijuana laws. Nations here is number 3, Arkansas, 9, Florida, and number 23, North Dakota. All of those states voted and approved new marijuana laws last week. So let's talk, and of course, this would be our prediction section. This is now our look we write section, unfortunately. But this is what we were anticipating leading up into the election, and let's look at what passed and what failed. Medical marijuana, Arkansas passed, issue 6 states. And let's look at how this affects the workplace. This amendment does not require an employer to accommodate the ingestion of marijuana in the workplace or an employee working while under the influence of marijuana. So we had stopped at that first half of the sentence. It's a good, better, best scenario where it's good there's this provision, but it could be better because it limits employer protection or employer's ability to end the workplace. Fortunately, it adds that second line about not having to accommodate working under the influence, and so it gives a little bit more, gives employers more of an ability to regulate and have a drug-free workplace, because obviously if someone's using off-site and coming into work under the influence, then that's not okay. But interestingly, we will see some other laws that passed last week where they don't add in that better provision, and they give us a good provision because it's better to have a provision for the workplace than to have nothing. We'll see the good, better, best as we look at these different laws. And unfortunately, if we look at the second point there, it does add in this: an employer will not discriminate against an individual in hiring, termination, or any term or condition of employment, or otherwise penalize an individual based upon the individual's past or present status as a qualifying patient or designated caregiver. I'll spend a little bit more time on Arkansas than the others because immediately we're seeing a lot of principles that we can apply and reuse when we get to their laws were passed. But here, a lot of people have interpreted the types of provisions to mean that these new marijuana laws are making dressing impossible because it can't discriminate. So it's a done deal, it's game over. When in fact, it's, in my opinion, forcing employers to take a live and let live approach to employees' medical marijuana use. As long as they're not coming into work under the influence, the law is requiring you to live and let live. However, because it says specifically that your employers are required to accommodate for the influence, if they come into work late, if they come into work stoned, if they're, any of these things are combining, then that is concrete workplace behavior that can be, disciplined under a workplace policy. So, general principles that we learned from Arkansas that will apply in some of these other states. Florida passed, and it has nothing in this section shall require any accommodation of any on-site medical use of marijuana in any place of employment, and it stops there. So it's good as this provision, but it doesn't go any further than that. So it's not talking about workplace policies, discrimination, or off-site use. It's not talking about discipline. It's not talking about drug testing. So two sides to this coin. There's nothing in the law saying that an employer can't have a drug-free workplace policy, but there's nothing in the law that is protecting an employer who has a drug-free workplace policy, which means we're going to have to see how this plays out in the courts, like we did in Colorado with Coates versus Dish Network. You know, and it was a favorable ruling in favor of workplace policies, workplace policies. We'll have to see if that holds true and that trend continues in Florida, because the law just doesn't say one way or the other. Montana, that passed, and it's actually, Montana already had a medical marijuana law. This just made it more commercially accessible, but it didn't change any workplace provisions, so no requirement of accommodation. Dakota passed didn't say anything about employers or the workplace, but interestingly, it did add a requirement to have drug-free workplace policies at passion centers for passion center employees. So they can sell the marijuana to medical marijuana card holders, but they can't, you know, they have to buy a drug-free workplace policy themselves. So that's a little bit wacky, but it's very interesting. And then we went to recreational marijuana. First off, Arizona Prop 205 failed. Now, a lot of discussion around Arizona Prop 205. It was not the end of drug testing as we know it, although it was worded in a way to make it seem a lot tougher than it really was. And so understandably, a lot of people read Prop 205 and were very concerned that that was going to be the end of employers' rights to drug tests, but wasn't, but it seemed like it was. And fortunately that failed, but there are a lot of lessons we can learn by analyzing Prop 205, because there's no doubt that Arizona legalized marijuana initiatives will return, and the kind of more bark than bite approach to marijuana laws will definitely see that again and again. So Prop 205 is out for now, but the lessons are there to be learned for the future. California, Prop 64 passed by like 1.2 million votes, like a huge margin. No surprise there. And it actually being such an easy win, quote unquote, for the pro-marijuana movement, it actually has a pretty restrictive provision that basically just says nothing in the law affects an employer's ability to have a drug and alcohol-free workplace. So that is unambiguous workplace provision built into the California law. Then with Maine, and this is a little bit of a mixed bag. There's good, better, best, but then there's also not so good. Nothing in the law requires an employer to accommodate use, consumption, possession, trade, display, transportation, sale, or growing of cannabis in the workplace. And that clause in the workplace. Add this provision, that third bullet point there, does not affect the ability of employers to enact and enforce workplace policies restricting the use of marijuana by employees or to discipline employees who are under the influence of marijuana in the workplace. So it's actually better than most provisions, because it actually says an employer can discipline employees for working under the influence. But it adds this, which is kind of the not so good. An employer may not refuse to employ or otherwise penalize a person 21 years of age or older solely for that person's consuming marijuana outside the employer's property. So that clearly is going to make pre-employment testing more difficult, but it does how exactly that will come to pass. So again, this is unfortunately something we'll have to wait and see how the courts handle it. I mean, the law doesn't require you to accommodate marijuana users in the workplace. Seems counterintuitive, counterproductive. The law would require you to hire someone that you know is not going to live up to your alcohol-free workplace policy, and have to turn around and fire, you know, once the grace period is over. So we'll have to see how this plays out, but that's, you know, we have good, better, and then not so good when it comes to Maine. And then we have Massachusetts and Nevada, a little bit simpler provisions. Massachusetts shall require an employer to permit or accommodate conduct otherwise allowed by this chapter in the workplace, and respect the authority of employers to enact and enforce workplace policies restricting the consumption of marijuana by employees. So that's a better provision, pretty straightforward. Just quickly, as I wrap up, I'll quickly draw your attention to the word restrict. A lot of us, as varied, that these laws say restrict instead of prohibit, that employers are not allowed to actually have drug-free workplace policies. They can just have drug-light workplace policies, so to speak. And in my understanding, the definition of restriction, if you look it up in Webster's or on Google, which is probably more likely, it says to limit something. And in my mind, you can limit something 100%. But so to see, I have no doubt that marijuana people worded it thinking that they're really clever for using the word restrict. We'll have to see if the courts agree with the interpretation of the word restrict, meaning up to not including 100%, or if they take a standard definition approach to the word restrict. But Nevada comes in and just says, does not prohibit a public or private employer from maintaining, acting, and a workplace policy prohibiting or restricting acts or conduct otherwise permitted under this law. So the anything goes state of Nevada is the most explicitly prohibitive of marijuana in the workplace by actually using the word prohibit. So again, if you have any questions about this, I went through a lot of information, so please use the Q&A. We'll try to get to those if we have time at the end. But that's what happened last week. So I'll turn the time back over to Nina.
Okay, so what I want to do now is to start to think about what Andrew just went through. 28 states, including the District of Columbia, that have legalized marijuana. Some are recreational, some are medicinal. Where I'd like to help you reframe this today is consider this. Marijuana is used and approved for medicinal purposes. Think about how smart legalization movement has been. Because somehow they circumvented the process that every drug in the United States coming to market has to follow, which is the phase 1, 2, and 3 clinical trials. So everybody knows when you buy a prescription, people say, oh, it's so expensive in the beginning because you can't make generics because the company who's done all of the R&D, all of the testing, and absorbed all of that expense is trying to make money on the thing in the first 7 years while their patent holds. It's medicinal, right? So if it's medicinal, why didn't it go through this process? So then say, okay, well, let's set it aside because this is the debate we've had for years, right? Let's set aside the idea that it's medicinal and say, all right, we're going to not go there because we don't want to now take the 6 to 8 years as legalized marijuana movement, right? We don't want to take that 6 to 8 years. Plus, we're not a drug company, so we don't have that kind of R&D budget, right? So now we're like, well, we want to know that. We don't want to have done all of these trials and find out what the side effects are, to find out what different strains are. And keep in mind, when you're doing this for like an opiate, right? An opiate, each different one. It isn't like you're about to say, hey, hydrocodone passed all the clinical trials, so now like every other drug that was an opiate-based drug has passed. That's not the case. Each different drug coming to market, be a synthetic opioid, be an antidepressant, has to go through this process. But that's not the case with all of these different strains of medicinal marijuana. So we don't know all of we don't know all of the side effects. So as an employer, we point this out because you know what the downstream impact necessarily of medicinal marijuana is going to be. Switch it and say, okay, let's skip that and just pretend it's recreational. Well, then it should. And this is just an example. This is not a tried and true process we've highlighted for you on this slide. But if it is recreational, then it would follow the path of alcohol, right? In that way, it still is going to have labeling and testing and approving. You're going to know what the proof is, right? You know the different proof on a bottle of wine or a bottle of beer or grain alcohol, right? And so it didn't go that way either. And things have really slipped through the cracks, which is great for the pro-legalized marijuana movement. But is it great for you as an employer? So let's learn a little bit more about the marijuana of today, and then you can answer that question for yourself. So a new study has found that marijuana, again, thinking trending here, right, has increased few decades ago, the potency was at about 10% or less, and now the potency has risen by a factor of 3, so it's closer to a 30% THC. So it's much stronger, right? Much stronger as a drug. Likening it to alcohol, think about the impact of alcohol to the United States, to taxpayers, to employers. Marijuana is the number 2 substance of abuse in America, second to alcohol, which is a legal drug, right? In 2006, that's the latest statistics we could find, excessive alcohol consumption cost the United States $223.5 billion. So assume if marijuana is going to continue to increase, and the use is going to continue to increase, it will, if not surpass, the use of alcohol in the United States. And so I'm not going to do anything extensive. I'm just going to do the plain old simple math, double it. And that the cost to the United States is going to be close to $500 billion per year by adding marijuana into the mix as a recreational drug. There's statistics that we're starting to see that are coming in that take this less from that philosophical conversation about should you or shouldn't you legalize marijuana, right? So think again about that trend of how many people are pro. Have they seen these statistics? Have they considered the facts? Not. I hadn't honestly considered a lot of these facts. So I wonder if others had, and maybe I just missed it. But the increase in fatalities and traffic accidents is significant. So if a driver is under the influence of alcohol, the risk of a fatal crash is 13 times higher who's not under the influence of alcohol. If the driver is under the influence of both alcohol and marijuana, which are very often the case, often the case they're using both, then the risk has increased to 24 times that of a sober person. So you're having people who are much more significantly impaired on the road. Couple that with the fact that we're seeing that drug driving accounted for more than 28% of traffic deaths in 2010. It's up from 16% in 1999. So again, 10-year-ish, I'm rounding, right, period, and you're seeing an almost double. You're 16% to 28%. We see those number of states increase. We'll see those numbers increase. You don't need the crystal ball to how this is going to go. Marijuana has proven to be the main drug involved in the increase. So 12% of those crashes in 2010 compared to 4% in 1999. We've seen marijuana traffic-related deaths increase. Now I'm going to pause before we get to this and just say one thing. There is no current way to say someone is impaired using a drug test. So again, we're going to talk a lot here about like the cart before the horse, how legalization has moved across the United States without really considering who is going to pay for the fact that the cart is before the horse, right? So impairment, we're going to talk about oral fluid drug testing and lab-based oral fluid drug testing and how it can help. Just like per se intoxication limits had to be set in states, things that are going to have happen, but they're not yet. So when you pull over somebody on the side of the road, there is not a state limit of how much marijuana can be in someone's system. It's going to happen. The science will continue to improve. The technologies will continue to improve. OSHA is working towards that. Others in the industry are working towards how are roadside testing. But you can't have a sobriety checkpoint for marijuana at the moment unless you were going to draw blood. Even that doesn't really equal impairment. There's a challenge there. And as that research is done, the cost is going to be absorbed somewhere. Where it's absorbed, I don't get the feeling from anything I've read or seen that the pro-legalization growers and distributors are footing that bill. So you can imagine who's going to. as that continues to have to happen. Go through some facts, and then we'll tie it to you as an employer. Respiratory issues. Smoke 1 joint is equal to smoking 5 cigarettes, so 4 joints equals a pack of cigarettes. Because marijuana smokers take longer, deeper breaths, you hold it in, with 3 to 5 times more tar and carbon monoxide in their bodies. Now go back to that slide that says, is it medicinal or is it recreational? We don't know, right? Because there's no label on the side that tells us all that's in that. It doesn't show me all the nutritional labels. Puffs do, but marijuana doesn't. Some states are starting to show what the THC potency is, but we don't know of the carcinogens that are in there. To see an increase of chronic cough, heightened risk of respiratory illnesses, and just like we saw the trends with tobacco smokers, just like we saw lawsuits, right? East Airlines flight attendants and pilots sued the airlines because you used to be able to smoke in the tube, just along the back of the tube, right? And then there were increased lung cancer cases, and paid for that line, the employer. Right? Start to think about this as an employer 5 years, 10 years down the line. Memory and learning. Smoking marijuana causes changes in your brain chemistry. It isn't, does it? Maybe. I don't think so. It's a fact, and so you can look up the details of that. But so that is going to start to affect the ability to learn, to focus, to remember. It has a decrease in motivation to accomplish tasks. For an employer, I don't think anybody does a job interview and says, tell me, what decreases your motivation? I'm with a decreased motivation. I'm looking for people who are going to have a little bit of trouble focusing and learning, because our core that we want. Those things are going to impact your workplace. And mental health. The long-term use of marijuana has been linked to increased prevalence of depression, anxiety, schizophrenia, and suicidal ideation. So again, back to those slides, is it medicinal, is it recreational? We don't know. All of these trials and tests have not been done. So what we don't know is it the marijuana that triggers the onset of the condition, making a pre-existing condition worse? Or is it a means of self-medicating the symptoms? Nobody, because it hasn't been studied to that degree yet. And so I saw a comment from someone, multitasking on the screen here, and someone says, the reason this hasn't been done is because the U.S. Drug Enforcement Agency severely restricts research because of the classification on marijuana. And that's true. That's why there's not so many clinical trials. But again, that doesn't mean the cart didn't go before the horse. That issue should have been resolved. Funding should have been made available. And then, as an employer, you wouldn't be picking up the tab for the inevitable outcome that's going to happen because of these facts. And so, again, that is why it happened, and that's clear. Doesn't mean that when you come to them as an employer and we start to see these costs, they're going to reimburse you because they didn't go that route. So look at some of the impacts on the workplace, and we saw that one of the major laboratories saw an increase from 2012 to 2013 of 6.2% nationally. And in Colorado and Washington, we saw these gigantic jumps. 20% positivity rate in Colorado, 23% positivity rate in Washington. So again, use your crystal ball and see what's going to happen after these states legalize recreational use. And tell me with a straight face that those people are or are not going to be part of your workplace. But they are. And you have a hard time compelling me to believe that they're not going to be. So let's look at all of these different facts and now see how they cost employers. We saw the facts. We saw the THC traffic accidents going up. We saw the workplace positives going up. What is it going to mean? It's going to start to mean an increase in workers' comp costs, increased absenteeism. And so then you've got to start to answer, should I still test? Can I still test for THC in light of all of that information that Andrew provided us? right? So let's talk a little bit about this. You can still test. It's part of an assessment tool. Background checks are, for those of you who run background checks or who are a background check provider. A drug test is part of an assessment. And use all the tools in your toolbox when you're assessing candidates. This is why you buy tests. It doesn't mean that that person's an exact fit, but you're trying to take all of the different tools you have to assess whether this candidate's going to be a successful candidate so that you don't take the burden of the cost turnover more than you have to. So it's going to increase stability in workers' productivity if you continue to test and you weed out the number of users in your workplace. It's going to do some of these simple things: decrease absenteeism, increase morale, reduce employee turnover. Why test? In the end, it's up the dollar, right? In the end, if you are in HR, if you are in safety, your company and your company performance comes down to that P&L statement. If you're privately held, if you're held by a venture capitalist, or if you are a publicly held company, it is ultimately about the numbers, right? And so you're going to start to see increased healthcare costs. You're going to start to see increased workers' comp costs. You're going to start to see increased turnover. And then we're going to talk a little bit about these two bottom ones. We're going to talk about all of them, but you start to see increased litigation expenses and increased tax liability as well. Well, you're going to see it because increased driving accidents, increased traffic fatalities, same increased incarcerations or arrests. We'll talk a little bit about that, but these are some of the, the increased incarcerations or arrests. That was a little bit of the message, right? Oh, we're no longer going to prosecute petty theft. We're no longer going to, or not petty theft, I'm sorry, possession charges. Okay, so not, but you're all of a sudden going to, the black market's not going to go away. There are users who are going to want to use, just like OxyContin went to the black market, right? You were not prosecuting the people who were legally distributing and manufacturing OxyContin, but you started to prosecute the people who were distributing it illegally. So the incarcerations are still going to be there. The people are violating the rules in the state are still going to be prosecuted. So although the makeup of the incarcerations and arrests that were, the decrease was promised by the pro-legalization movement, as we start to see these numbers trickle in, we're starting to find that the reason for the incarcerations have changed. But the numbers may not be so significant as we see an increase to legalization recreationally and medically. So as an employer, what do the increased driving accidents mean? And the increased traffic fatalities means you're going to have workers' compensation claims increase, which means an increase to your premium. Increased property damage when they crash the car. The state's not going to pay for it. The distributor's not going to pay for it. You are. Increased company liability. When they crash that car into X, Y, and Z, it's insurance, they were on the job. Increased auto insurance costs and premiums. Increased taxes to support criminal impact if you're a taxpayer. Look at the issues we talked about, respiratory issues, cognitive impact, mental illness impact. You're going to see increased healthcare costs. You're going to see increased short and long-term disability claims. So you're going to see that impact in terms of the absenteeism in the workplace, and you're going to see the impact of that in terms of your premium costs. As we talked about the absenteeism and the turnover, you're going to see the increased inpatient and IOP programs. And I know that Nicole is on from ASAP today, and I'm wondering if they've started to see that. Have we seen an increase as trends towards the amount of use of alcohol in the United States? Are we starting to see an increase in inpatient and IOP programs, intensive outpatient programs for people who find that they're using it too much? And are you addicted? Are you not addicted? Sometimes that's something that goes in the four walls of your house. Where it's like alcoholism, someone says enough is enough. Your spending on this is too much. Your use on it is too much. The impact to our marriage, to our family, to is too much, and so they go into an inpatient program to learn how to curb or stop use. Delegation cost is significant, and here's the trick. If you're right, as an employer, are going to pay to go to court to prove that you are. Those current questions and a million more are being litigated now. And it very well may be the case that in the majority of these cases, the employer is found to not be in violation. But that does not mean that you as an employer have not spent $100,000, $200,000, $300,000 on your law firms to fight it. Doesn't mean there's not an impact to your brand when that case is public. And so there are costs to you, and if you're not paying attention to how this legalization is going, and if you're not active in it, it's going to be a burden. And so you have to think about it, because there's just a connection of the dots. It isn't pro, con, or indifferent. If you're indifferent and it keeps going pro, there are going to be costs. And again, who's making the money? States will make it in tax revenue. The growers will make it, the distributors will make it. Everybody's seen an article where somebody's making so much cash and they can't deposit the cash and they have, houses full of money. Well, that's good for them, but they're not going to pay your lawyers. They're not going to pay your increased workers' comp premiums. They're not going to pay your short and long-term disability premiums when they go through the roof. Money the taxpayers, individual employers or businesses are going to be heavily impacted, and not a discussion that pro-marijuana movement is having. So when you look at it at policy, there are important things that you need to do as an employer to ensure that your policy does not run afoul, because you don't want the double whammy, right? You don't want to have to pay to fight it and then have to pay when used because your policy was not correct. So really important things for you. You want to make sure, you want to remember that marijuana is legal under federal law, and so you can for it. It is a Schedule I drug across the entire United States. There is nothing in any state with there are distinctions within each state and how you have to write policies, but you can still continue to test for and prohibit under the federal law, the Schedule I Controlled Substance Abuse Act. They announced and upheld that in August of 2016. And I'm not going to lie, everybody was a little bit concerned about whether or not that would change. And the courts in general have ruled in favor of employers seeking to prohibit marijuana in the workplace. So what does that mean? It means you can still prohibit possession, use of, or impairment by marijuana. And because we talked about the technology not specifying what impairment means, you have to be very clear in your policy. You have to test under your program. If you're DOT, you can still test. And you have to be clear about the consequences of a positive drug test. So you want to list your prohibited behaviors. You want to talk about when and how you're going to drug test and for what, the consequences, and you'll be very clear that you can't possess or use marijuana in the workplace under the influence. And under the influence can be defined as positive at or above the level in your That's okay. We'll move quickly now into what the OSHA regulations are and tie this all together for you for oral fluid drug testing. So the OSHA regulations came out in May of this year and confused a lot of employers, much like the medical marijuana laws did, by saying, there's an additional responsibility for employers who are covered under OSHA in terms of post-accident or post-incident. And there was a panic that you could no longer test for post-accident drug testing if you were an OSHA employer. And nothing could be further from the truth. That has been upheld, and it has been clarified as late as, I think, October 16th or 18th of this year. OSHA came out clarifying that is not the case. What they said was this very broad new regulatory policy is about reporting, and what they don't want to happen is to have someone discriminate or retaliate against an employee who reports an injury or illness. And so you can still test following an injury You can still test in compliance with the drug-free workplace. You can still enforce safety rules in your company, but you can't do retaliatory terminations or drug testing. And so it is rather complicated, but it's really not. It simply says that you do not want to dissuade people by an overly restricted blanket drug testing policy. And so when I hear things like that, it sort of swirls in my head, and I think, I'm not % sure what she just said to me. So a couple things. If you're working under a voluntary or mandatory state law, a workers' compensation denial, premium law, or another state or federal law, you can test. These rules only apply to drug testing employees for post-accident and employers who are covered under OSHA. So it doesn't apply to pre-employment, any other reason. It's just that post-accident testing. It doesn't violate any of those state or federal laws. So what it says is that you as an employer have to have an objectively reasonable basis for testing. The third bullet specifically cites what we're going to look for in terms of what the elements of retaliation are to prove a violation. So in order for OSHA to determine if there was a violation, they're going to look at your policy and practices as an OSHA-covered employee to make sure that you have a reasonable basis for believing that drug use contributed to injury or the illness. So you shouldn't drug test. For repetitive injury, carpal tunnels, very difficult time showing that when someone reports an injury because of carpal tunnels, that it required a drug test. So what you really want to do is, as an OSHA-covered employee, you want to have a policy, practice, and training that sort of takes a second step and uses a decision tree that says, okay, is it reasonable that drug use could have contributed to this illness or this accident? And if so, it's okay to test them. Are all employees in the incident required to be tested, or is it just some? You don't unfairly disadvantage somebody or retaliate against them. That is really the test that's going to take place in the workplace. And so when you look at it as an example, we're going to talk about impairment. I'm going to go back to that. But when you look at an example, if someone crashes into somebody else with a forklift, then it's reasonable that you would test the person who was driving the forklift, but it's also okay to test the person who, was standing there and didn't move out of the way. And so you really want to have a decision tree that you go over with your managers and that evaluates whether or not it is reasonable to test one or all people, part of that injury report. When they originally in May came out with these regulations, they talked about impairment at the time of the incident, and that OSHA said that you'd use a drug testing method that accurately identifies impairment. But we talked about this in the beginning, and there isn't a drug testing method that says, yes, this person is impaired at this level, this amount of drug in the system. So they've sort of clarified that in this October statement, and they've talked a little bit, they've clarified what that means. And so they've really said, all right, I mean, they didn't say, hey, we're wrong, but I think they kind of did say we're wrong. And what they really said is that until there is something that can very specifically indicate impairment, that you can use an alcohol test to measure alcohol use, but you can use testing methodologies and workplace policies and use a positive drug test discipline under OSHA, and that's okay because they now recognize that there isn't something that will necessarily indicate employment. So again, by way of example, look at a crane accident where several employees working nearby are injured. Could you test, right? Could you test all employees who've contributed to the accident or were part of the accident or illness? That's very appropriate in this case. But back to that repetitive injury or illness, it wouldn't be something. So you can take the reasonable possibility that the driver, even though that person wasn't injured, could, and then anyone who was injured in that incident, and you can test them at that point as well. The employer only tested the injured employees but didn't test the operator, have a problem. Because it's disproportionately the employee who had an accident. So that's a fine line, right? You would test everyone, whether they were covered under, whether they were injured or not, would test them in that case. It doesn't prohibit you as an employer from administering a drug test, but it does prohibit you from doing it in a punitive manner. And that's really what's important. So your ability to test is really not been hampered. You just want to consider it that way, make sure it's not punitive, and then we're going to talk about it. But let's talk about impairment and oral fluid. Lab-based oral fluid testing is an excellent way that if you're still queasy, right, if you're still nervous about am I or am I not, I'm concerned about this idea of impairment, I maybe am leaning a little bit more towards, or I'm in a state where there is recreation or medical marijuana, then lab-based oral fluid. I mean, look at it across the country. Look at it across all of your testing, because it does a lot of phenomenal things for you in terms of, cost and maintaining cost across rural and local high testing and low testing areas. But it's not as invasive or costly as blood testing. And in 24 years in this industry, I know very few clients who do blood testing in the workplace. It's extraordinarily invasive. Hair testing, although it's great to show a very wide back look at your drug testing and drug testing use, in terms of what we were just talking about post-accident, if you are looking at, hey, when I'm hiring, I want to look at sort of near-term decision-making as an assessment tool, I don't necessarily want to know if the person smoked, a week ago, then testing might not be the best option. And urine testing has a wider window of detection. But what's great about lab-based oral fluid testing, hold on, I'm going to show this slide, is it's very immediately after the use. So if you go back to that crane incident, right, it's like a week, like hair testing. It's not going to take hours like urine testing. It's going to take a shorter window for you to see a positive oral fluid drug testing. Same as blood, right? But it's as invasive as blood. And so look at that window. What that window does is it still doesn't say, hey, impaired or hey, not impaired. But what it does is it really more closely links to that shorter window. It more closely says the person was likely to be impaired in some way, shape, or form. But it really ties in that window. So if that's your concern as an employer, think about how tight that window is. The good news is, across the board, in the 15 years I've worked with oral fluid drug testing, you still see a significant positivity rate. Wasting money on drug testing, you're not saying, oh, well, we're going to miss a bunch of people. I don't want to miss a bunch of people. You're not going to miss a bunch of people because you're going to administer that drug test right there on site. To give a candidate 40 hours to go get a drug test, you're going to say, here, put this in your mouth. I'm going to watch you and observe you doing that collection, and we're going to send it off to the laboratory to have a laboratory-based oral fluid drug test, and you're going to see positivity rates that mirror that in a urine testing program. So see some of the benefits. We listed them already, but you're going to get that closer link to recent use when lab-based oral fluid drug testing. And like I said, when you look at the statistics, you will see that the positivity rates for oral fluid drug testing, again, back to like pre-employment drug testing, you're saying, I don't want to leave them on the table. Look how significant you're getting near-term use as a candidate assessment tool. You're getting to see if this person has, was there an addiction issue and they could not stop long enough? Were they not interested enough in coming to work for me as an employer that they didn't stop? They didn't do diligence to see that we did drug testing? It's a great way to hone in and improve your assessment tool of candidates and employees. So what are the actions you can take away from an OSHA perspective? You want to look at your policy, specifically post-accident and incident definitions, and make sure that you do not have a blanket policy, but rather go to that last bullet and say, hey, there should be some form of a decision tree when incident reported. We're going to follow that. We're going to train on that. We're going to train our managers on that, and we're going to document, because what you remember today is not going to be what you remember when OSHA comes in and maybe does an audit. So document what the decision tree is. And at CCG, we have a decision tree that's a sample. You can look at what a decision tree would look like and make that determination. Okay, this person came in and they reported carpal tunnels. We're not for this one. This person was part of an incident or accident, but did not require medical attention and did not report, but drug use could have caused that. Then we are going to, and we're going to test the people who were involved in the incident as well, if we can assume reasonably that drug use could have contributed to that accident. So you want to do that in your policy, review your policy, review your procedures. You want to make sure that drug testing is just a part of that overall incident-accident evaluation, and you want to make sure that your policies and your procedures are non-discriminatory when you're looking at drug testing and drugs as a contributing factor. You could consider looking at some of the rules that are tried and true by, if you're doing post-accident testing, you want to use like an 8-hour or a 32-hour rule, 8 hours to do alcohol testing, 32 hours to do post-accident testing. The good news is if you're using oral fluid drug testing, you can usually get in with an hour or two if the person's not requiring medical attention that's off-site, have the medical attention sought after, and then perform the drug test, and you're not even waiting that long as you have to with urine-based DOT drug testing. And then training. Training is key. Train and document that you've trained, because again, it shows OSHA, it shows that you are trying to comply to the best of your capabilities. And then remember that the reasonable suspicion findings should be documented. And then look at lab-based oral fluid. It can be piloted, it can be tried, it is allowable in 47 states. Look at it. If you fall into those categories we talked about where you have some more concern, or you like to tighten your window, but you want to still see a lab-based test, and you want to still see that your spend on your pre-employment testing is, it's budget-friendly, so that's lovely, but you also want to make sure that your spend, you're seeing the ROI on it. And when you look back at that positivity rate slide, you can see that you're still restricting the window to comply with some of the OSHA, not comply, because they all comply, but, you're still restricting the window to really meet what OSHA was trying to do, but you're still using an extremely effective assessment tool, an extremely effective deterrent tool, and it is easy to roll out. You're a national company with 3,200 sites. Oral fluid drug testing and transitioning to it is not a difficult 12-month process. It's something that you can do relatively quickly working with your provider. So questions, we have a few. We've got a bunch that came in, and we've answered several. We will follow up from the answers. From the questions that we got. And a lot of them were related to the FDA and the classification and sort of the testing. So we can give you some more information on that. And Jessica, I'll let you sort of wrap up, but we'll answer any more questions that we have as part of the presentation and make sure that everybody who's attended today gets copies of those answers, since we didn't have a lot of time to do that during the presentation today. So with that, I'm going to turn this back over to Jessica.
Thank you very much, Nina and Andrew. And on behalf of OSHA Technologies, we hope that you have found today's presentation informative and helpful. This presentation was recorded, and you will receive instructions informing you how to access the recording, and you will also receive a copy of the slides from this presentation today. If you asked a question that was not answered, as said before, we'll send out the answers to those questions to you after the webinar. We thank you for your attendance today, and this concludes today's webinar.
Thank you.